Okay, so we're going to get started here, and you should all be able to see the PowerPoint on your screen. And what we're going to do is we're going to try and get through this in 30 minutes. And what I would like everybody to do, as I said, is put your audio on mute so that we don't hear feedback from each other. It sounds like everybody is on mute right now. And if you have any questions, you can type them into the chat box in the webinar, and I'll get to those questions at the end of the webinar. And also later on today, we'll send you all an email with the PowerPoint and a link to the material that we're going to be discussing, as well as a link to a recording of the webinar, so you can give it to other people in your office if you want them to view it. So with that, let's get started. We're talking about dividing military retired pay after the National Defense Authorization Act amendments of 2017. And I'm going to start by giving just a little background on what the basic formula for retired pay is, because it's important to keep this in mind. The basic formula is somebody's retired base pay, and there are a couple ways to determine that, which we'll talk about in a minute. But it's basically pay times a percentage times years of service. So in the end of it, the nub of it is that there are two factors. There's what is the retired base pay that goes into the formula, and what is the service that goes into the formula. And the amendments that we're talking about were made to the definition of disposable retired pay. So this slide shows you the definition of disposable retired pay with the addition that was made by the amendment back in 2016 in black. And basically what disposable retired pay is, you start with total retired pay, which is the formula we just looked at, and then you take a few things out. You deduct the cost of the survivor benefit plan coverage, and most significantly, you deduct any pay that is waived, the disability pay, which somebody may have waived their retirement pay in favor of getting disability pay. The reason they would do that is because it's not taxable, it's a disability payment. And so once you take your total pay, you take out those deductions, then you get what's disposable. That means what can be divided between the parties in a divorce. So the key thing is that the amendment said, when it comes to determining retired pay to which a member is entitled, that's going to be determined pursuant to the new subparagraph B that was added, which is the next slide. So what the amendment does is it says, when you're determining total monthly retired pay to which the member is entitled, which is what we're trying to divide, you take the amount of basic pay payable to the member for their pay grade and years of service at the time of the court order, and then you increase it by cost of living adjustments that occur after the court order. So the key thing there is in number one, the key point is in subparagraph 1, which is when we're determining basic pay that we are going to divide in divorce, we have to use pay grade and years of service at the time of the court order. And the second point is any cost of living increases that occur after that will accrue to the benefit of the former spouse. So that raises the question, well, what is the member's pay grade and years of service at the time of the court order? That's the key place we need to focus here. So let's take a look back at the basic formula again. It's retired base pay times the service multiplier. A couple notes. Retired base pay is not determined the same for everybody. If you entered service before September of 1980, it's your final pay, and if you entered service on or after September 1st of 1980, it's high 3, which is the monthly pay of the high 36 months, 3 years from the pay charts. So the other point is that when we're talking about this formula uses years of service. If somebody is in the reserves, basically you take all of their points, and 360 points equals 1 year. So let's take this example now is just to give you an example of how the retired base pay works out for a high 3. And we're going to take a look at we'll take a look at the pay chart. Hold on a second. So here's the pay chart. This is something that all of you should be familiar with when you're dealing with issues that might come up. And I wanted to spend a little bit of time just showing you what this pay chart looks like. If you look across the top of the chart, you've got the years of service that somebody's in the service. So basically, as you progress, even if you don't get a promotion, as your years of service go up, you may well get a pay increase due to the fact that you've been in the service for longer. That is not always true. Sometimes, at some point, a lot of the pay grades will cap out, and more service doesn't result in an increase, but in many cases it's true. So across the top of the chart, you see the number of years of service that the person has at the time you're trying to determine what the pay is. And then across the side of the chart, the left side of the chart, that's their pay grade. So promotions would move somebody up these pay grades, and when you're determining high 3, you would need to know what their pay grade was and how many years of service they had in each of those 36 months that you're trying to determine what the high 3 is. And that would all come off of this chart. Each year, these pay grade charts are reissued and incorporate any statutory increases in pay, as well as any cost of living increases. So with that, let's go back to the presentation. And so the example I gave is an E5 with 20 years. They have a high 3 of 3,232, because if you look on the chart, that's what comes out of looking over their prior 3 years. They are one of those people who did not get a pay increase. And for them, the way the formula would work would be, if they retired at 20 years, monthly retired pay would be that high 3, 3,232, times 2.5% times 20, which means times 50%. And that gives you the amount of retired pay that they would get at 20 years, if they retired at 20 years. So the question we're addressing is Van Loan debt. So the traditional Van Loan formula divides monthly retirement benefits based on a marital fraction. And the marital fraction is the service accrued during marriage divided by the total service at retirement. And then you're multiplying that by the monthly retirement benefit that is received at retirement, and then giving half of that fraction. So using a traditional Van Loan formula, both the marital fraction and the retirement benefits that we're dividing are determined at the actual retirement date. And this is just forget about CALS for a moment, which is perhaps a modification of that. It's not actual retirement, but a theoretical retirement. And so one of the implications of Van Loan is that any post-marital promotions or pay increases that somebody gets, to the extent that post-marital pay increases impact the amount of the retirement benefit that is received, which is true in military, but it may not always be true. But to the extent that post-marital promotions and pay increases increase the retirement benefit, then the former spouse who's getting a share of that gets a stake in those post-retirement benefit increases. And that is the piece that is modified by the NDAA amendments. So the amendment modifies Van Loan to say that the pay that we're determining when we're applying the formula about what we're going to award to the former spouse is determined at the time of the court order. And that's a quote from the statute. So again, back to you've got a service fraction and you've got a pay issue, a pay portion of the retirement. The only impact here is really on the pay. It's not on the marital fraction. If you think about the marital fraction, if the pay stays the same, it doesn't really matter when we determine the marital fraction, whether we determine it at the time of the divorce or after the person's accrued more service, because the fraction itself will always yield the same number, which is, think about it this way: if there's 2 years of service and one of them was marital, 1 out of 2 is 1. And if there are 3 years of service and one of them is marital, that 1 is now divided by 3, but it still comes back to 1 because it's 1 out of a larger number. And so you always will land up with the same time fraction. That is not the issue that we're dealing with. It's the effect that the amendment has on the pay portion of the formula. So Van Loan is not completely dead, but did take a bit of a shot, and it is modified when it comes to military retirements. So this raises the knock-on question to that answer is, well, what is the time of the court order? And this is an issue we've dealt with over the last year or so since the amendments went into effect, and many of you on the webinar know that I've gone through a couple of iterations of this, and we've argued and thought, and we probably in some cases still disagree, and will disagree in the future. But it's an issue that I think presents opportunities as well as presents some risks for you, and things you need to think about and make sure that you're addressing it. And it's resolvable. These issues are resolvable, and I want to make sure everybody's aware of that. So the statute itself says, well, the term court order defines the word court order, and it means a couple things. Either it's a final decree of divorce, dissolution, annulment, or legal separation case. So that's pretty simple. The time of a decree, dissolution, annulment, or legal separation seems to me to be the date that decree, dissolution, annulment, or legal separation is entered, is issued by the court. But then the second part of this is the term court order means a court-ordered, ratified, or approved property settlement incident to a decree. So I think one natural reading of the statute and the definition together would be the time of the court order certainly could be the date of the decree, if we have a decree that says what we're doing. But what about if you have a decree that incorporates a marital settlement agreement? Is it the time of the settlement agreement that was ratified by the court, or is it the time that it's ratified by the court by being entered in the decree? Or could it be a date that you specify in the decree? Could the time of the court order be a time that you say, well, parties agree the time of the court order is X? That is unanswered to me, but if you don't answer it, my view of it is the time of the court order is the date of the decree. Unless there's something that tells me it's some other date, the time of the court order, to my mind, would be the date of the decree, and that is consistent with what DFAS has kind of implied in their model orders, language that they've issued to implement this. But they haven't really gone into detail to think about these issues, and I think it's definitely possible for the parties to discuss and say, let's specify in our decree or in our marital settlement agreement that the quote time of the court order is fill in the blank. And this is an issue for argument. It might make a difference for reasons we'll talk about, and it might not. I have some thoughts about concepts that you can use to argue with each other about what it should be, which we'll talk about as well in a second. It's not automatically the date of service, but I think it could be the date of service if your decree says that it's the date of service. Let's talk for a second now how these changes play out when you have pre-retirement versus a post-retirement divorce. With post-retirement divorces where the time of the court order, no matter how you count it, is after retirement, it doesn't really matter because there are no post-divorce pay increases due to additional service, obviously because the member is retired. In that case, we know all of the variables, and so we can reduce the award either to a straight percentage or to a specified dollar amount. And we'll talk a little bit more in a second about what the distinction might be between those two and why you might pick one versus the other. The more interesting case is the pre-retirement divorce. When we have a pre-retirement divorce, we have to specify for DFAS, first of all, how much service, either points or months, are marital. And that's determined by the parties you need to calculate, and that would be between the date of marriage and the date of service. With that information, DFAS will calculate what that time-based marital fraction is. So we're all good there. Then we also have to specify to DFAS in our order the total service and the retired base pay at the time of the court order. And so this presents some challenges in some cases. For example, if we're trying to do this, or if we've determined the time of the court order is the date of the decree, and we're not at a decree yet, we're trying to enter the decree and the order at the same time, we don't necessarily know exactly how much service there's going to be at the time of the decree. So we might need to wait and get the records or extrapolate out, and everybody agrees. Presents an issue there. One point I want to make to everybody is to remember that we're talking about, we're arguing over what we're going to have an issue over and a potential argument over is when you're looking at what is the time of the court order, whether it's the date of service, the date of the decree, or the date we enter the order dividing military pay. The key thing we're most likely that makes that worth arguing over is whether there were any promotions or service-related pay increases in the 3 years between before the date that we're dealing with. So if you have somebody who has capped out and isn't getting any pay increases due to additional service, and hasn't had a promotion in the 3 years before the date of service or the date of decree, then don't argue over that. It makes no difference. That part of it doesn't matter. From the perspective, well, that part of it doesn't matter at all in that case. It doesn't matter what we use. You're going to come up with the same result. So focus on determining whether you have an issue here. Focus on whether the member had any promotions due to service or due to any pay increases due to service or due to promotions in the 3 years before any of the potential dates that we might be using. The other issue that this brings up sometimes, which I think is something that if you are representing the former spouse, I think you should argue this. I would certainly argue it, and probably I have argued it with a few of you on the phone, on the webinar, and I'm sure most of you will probably think it's wrong, and it may well be wrong, but it's not necessarily wrong. And I think it's an argument that can be made. So if you take the concept of under Van Loan says that premarital service is weighted equally with the marital service and the postmarital service. All of the service gets the same weight when we're determining how to divide up the benefit at retirement. It's just purely time-based, and everybody gets a share of all of the increases that occur in pay up through the date of retirement, both pre-marital, marital, and post-marital. The amendments to the NDAA say specifically we have to weight the post-marital service more if the member has post-marital promotional service-related pay increases. That's literally what the implication of the NDAA is, that post-marital service gets weighted more if there are pay increases. And I think that raises the argument to make to a court and to your opposing counsel if you represent the former spouse, and if there is premarital service, that, hey, if we're going to do that, shouldn't we also underweight the premarital service on the same principle that that's not marital and it shouldn't enjoy the benefit of the marital service if the marital service isn't enjoying the benefit of the postmarital increases. It's an equity-based argument. Certainly, I can see the counter-argument that says, well, that's wonderful, but the NDAA specifically modifies our existing law, and we have to modify it to give that extra weight to the postmarital, but it doesn't say a dang thing about premarital service, and that's true. But still, I can see making an equitable argument that that's what should happen. So I guess the question whether that's persuasive to you is who you represent. Another point that I want to make sure everybody is aware of, this is an important practice point that arises out of the Howell case, the Supreme Court case. And the background of this is that you cannot award more than 50% of disposable retired pay to a former spouse. And so a lot of times what happens is you make an award, even let's say you make an award of 50%, so it's all service is marital at retirement, and you're making an award after retirement. You have divorce after retirement, so you're getting 50% of disposable retired pay to the former spouse. And then the member waives some of their retirement pay in favor of disability pay. That will reduce what the former spouse gets, because the disability pay comes out before we can dispose of the retired pay. And you cannot respond to that by saying, what Howell tells us is that you cannot respond to that problem by saying in your decree or somewhere else that the member has to indemnify the former spouse for the loss of their disposable retired pay due to that waiver in favor of disability pay. So I think that would be true even if we hadn't awarded 50%. If we'd awarded 25%, let's say the marital period was half of all service, and we awarded 25% of the disposable retired pay to the former spouse, I don't think you probably can't come back and say, hey, 25% used to be X dollars. Now that we waive, 25% is no longer that. Increase the award. You could try. I'm not sure that would work. I wouldn't want to be relying on that if I were representing the former spouse. But what I think you clearly can do is you can deal with this problem of how if you convert the award instead of a percentage into a dollar amount. Now that only works if you're awarding less than 50% of the disposable retired pay. If you're awarding 50% of disposable retired pay and you convert that to a dollar amount, if there's a waiver, your dollar amount won't work because it'll become more than 50% of disposable retired pay. But if you're awarding, say, 25%, it may well be good advice for you to convert that 25% into dollars. And that way, if the member waives some retired pay, the disposable retired pay will go down, but your dollar award may not result in it being more than 50%, and you will effectively have preserved the former spouse's award. And that's something I think is frequently overlooked. So with that, let's get a few. I have some sample language here that is here, and you'll all get it in the PowerPoint, in the email that you get after the webinar. So you can. This is. Don't use this language as it's not written in stone for every situation. Obviously, you have to think about it, but it highlights some of the issues you need to address. If we're dividing up post-retirement, then we're going to give 50% of a marital portion, or you're just going to give straight up 50% or some other percentage if we want to reduce it to a percentage, or a straight up dollar amount if we can reduce it to a dollar amount of the member's disposable, military disposable retired pay. And then this defines how we're going to determine what the marital portion is. Let's specify the dates and the number of months and points that were accrued during the marriage. That way you don't have to fight about it later. And I can't tell you how many times I get referrals to draft the order, and then we start arguing over what was marital and what was not marital and how much service was accrued during marriages. It just makes it so much harder. Obviously, it makes my job harder, but it also makes it harder for the parties if you don't resolve this beforehand. And while you have the ability to do discovery and to get the information you need, I recommend that you specify the particulars, what the dates were, how much service was during marriage, and then you can agree also as of the date of the if you have total, if this is post-retirement, then you can specify how much service there was at retirement. And then there's an optional provision there if you're going to preserve the survivor benefits that were awarded. Pre-retirement language is slightly different. This just requires us to specify the total service accrued by the member at retirement based on the service and retired base pay on the date of the decree, and we put some details in there about what that is. So you can take a look at that language and you can start working from that. And everybody on the call, if you're in a situation where you're not sure about what the answer is, feel free to type up proposed language, send it to me and say, here's the issue I see. Do you have any suggestions about how I might deal with this? And I'm always happy to tell you what I think. If you have any questions, please type them into the chat box on your in the webinar, and I will try and take any questions that anybody has here.